Rules of the game. Rule number 1. The fiction and real cannot mix. The public and the private cannot mix. You cannot create a public debt. That is against the law. A creditor can issue a bond, evidence of a public debt, and use the bond to discharge other public debts. You cannot use the public Federal Reserve routing numbers on the private credit instruments you issue. Those routing numbers are public. Your credit instruments use your private routing number, IN, with the closed account number. You are a private banker. The closed account number was accepted and put on AUCC1. Your acceptance of the account number takes it to the private side for adjustment and set-off. You gave notice to John Snow, or his predecessor, that you had accepted the account as collateral. Your secured party collateral rights are private. You are a secured party on the private side even without filing a UCC1. The UCC1 is to give notice on the public side of your collateral rights. That is why you can use the account for adjustment and set-off of public debts. There is no money on the private side. Debt is used on the public side to discharge other public debts. There is no money on the public side either, but debt is accepted as money. The debts that are owed to you by the public can be used to discharge public debts. A debt is a liability to the debtor and an asset, a bond, each time you use your credit. You can bond your bill of exchange, or use a bond. Either way, it is a bond, evidence of a public debt owed to you, that discharges the public debt. If the state cannot file a claim against you, because it is a fictitious entity and you are a real man, then it must file a claim against a straw man to get to you. What is it trying to get? Does it want your body in jail? The money in your bank account? Your house? Your business? The answer is no. It wants your credit. It already has the rest of it, because everything is either registered or found on registered property. The state does not want the things that are held in the name of the straw man, but it has no compunction against taking those things, if you dishonor it in any way. All those things, except your body, belong to the straw man, which is an officer, agent, or employee of the U.S. or one of its states. They do not belong to you. The money, FRNs, belongs to the Federal Reserve, because it is the entity that created it. The straw man just gets to use it as long as it follows the Federal Reserve rules. The title to the real property associated with your house is held by the straw man. The business license for your business was issued to the straw man. The registration for the car names the straw man as the owner. The driver's license was issued to the straw man. None of those assets belong to you. They are all pieces of paper that belong to the straw man, unless it fails to follow the rules. Presentment has a complaint, a moving party. What is it trying to move? What is its complaint? It is usually using a statute as the grounds for the complaint. If public and private can't mix, the complaint must be against the public straw man, not you. Why would the state care if a piece of paper violated a fictitious law? What is the motivation? State is trying to move you to let it use your credit. If you refuse, the state can move the court to grant the use from your dishonor. Does the state really have a complaint, or is it just asking for your help? Maybe the complaint is that it is out of money. There is no money. None on the private side, gold and silver. None on the public side, except your credit. Does the office manager do when it needs more money for paperclips? It requisitions the guys on the top floor for money to buy more paperclips. Do the bosses say, "No way"? Of course not. That would be counterproductive to the purpose of the business. Think of the state as your business. You need to be sure there are enough paperclips, or the business may fail. Why would you refuse to honor the requisition? Why you argue about whether or not the requisition form was filled out properly? Why would you deny you are the proper party to fulfill the requisition? Why would you ignore the requisition? Why would get mad and start charging the messenger with fraud? If you ignore the requisitions and spend all your boss's money trying not to fulfill the requisitions, the business will fail. Where would that leave you? Your business is down the tubes. You might be in jail for breach of contract. Your property has been taken by the corporate attorneys. Your money is gone. All the people who depended on your business have to use other sources of your products and services. You are a very irresponsible businessman. If you had just signed the requisition, you would still be on the top floor. Instead, the trust assets are gone and you are making license plates. The state has no substance. It has no money. It has no inherent right to anything, except what it has created, which is the straw man. It has a very important function. It has been charged with providing for the means by which you can go into grocery stores, gas stations, libraries, shopping malls, airports, car dealerships, and marts. It does not get money from somewhere. It cannot continue to provide the infrastructure you find so convenient. The only source it has is taxes. License, permit, and registration fees are a source of revenue for the state, but that is not sufficient for the giant octopus feeding machine we have grown to love and depend on. It needs to feed off your credit, and if you don't voluntarily let the state use it, the state will use your dishonor to take it. If you have filed a claim against the straw man, the state doesn't even control that anymore. If you have named the Secretary of State as the secured party, it has additional expenses as trustee of the property held in the name of that straw man. The situation is getting worse for the state. Where will it get the money it needs to continue supplying all the services you expect from it? It has to go to you and ask you for your credit. Have you ever had to ask your dad for financial help after you left his house and were out on your own? It is embarrassing. The state does not want to just ask if it can use your credit. It will have to find creative ways to ask for it, get it, and save face in the process. The trick is for the state to ask for your help without the unenlightened person, US citizens, being able to see it. The state must have your credit, and it is going to get it one way or the other. It is going to get it the easy way or the hard way. It is all up to you. So the only thing the state can't take is your body and other substance in your possession, unless you voluntarily authorize the state to use it. You always have a choice to retain possession of your substance, or let the state take possession of it. Remember, possession is 9/10 of the law. What is the other 1/10 then? Honor. Rule number 2. Stay in honor at all costs. Your mission, should you decide to accept it, is to honor the state when it asks you, in its aggressive way, to let it use your credit exemption. The state is raising you up as a creditor every time it gives you a presentment. It is your choice. You can honor the state by accepting its presentment and issuing an authorization voluntarily for it to get enough of your credits to equal the value of its presentment. Dollar for dollar, or you can voluntarily dishonor the state by refusing, arguing, making it prove its claim, or defending the straw man, pretending the state has no right to make its claim. Wow, that is a hard choice. You can voluntarily authorize the state's use of your exemption, or you can voluntarily dishonor the state, at which time it will use your dishonor to take property from the straw man or take your body and collect rent while you sit in jail. Gee, what should I do? What should I do? There is an easy way and a hard way. The choice is always yours. The state is only following your lead. If you argue or defend, it gets to use your exemption and maybe take some of your possessions besides. If you accept and authorize the state to use your exemption, it is required to accept it. What do you have to lose? Is your exemption limited? Can it be depleted? No. What difference does it make if the state gets to use your exemption? The difference is, the grocery stores and Walmarts stay open. The fire department responds to fire calls. The garbage trucks pick up your garbage, and the streets are repaired. When you understand how to stay in honor, it is a win-win situation. If you do not know how to stay in honor, it might be a win-lose situation, with you losing. The state will get what it wants either way. Rule number 3. There is no money. What do you use to pay your bills? If there is no money, what does the state use to pay its bills? Do you really have any bills? Whose name is on the contract with the electric company, the mortgage, the credit card, or the student loan? It isn't your name. It is the straw man's name. The Constitution says, "No state shall make anything but gold or silver coin a tender in payment of debts." Well, there it is, a prohibition against the states. Does it say the United States or its agents can't use something other than gold or silver for payment of debts? No. Since there is no gold or silver coin in circulation in the United States, and all the businesses you have grown to love are in the United States, it is a good thing the United States has created a straw man for you to control and Federal Reserve notes for it to use, or you would use money, if you had some. The straw man is able to pay all its bills with Federal Reserve notes. You can't, but the straw man can. Isn't it neat that you control a straw man, person? The trouble is, the straw man can't get a real title to anything with Federal Reserve notes. You can get possession of the substance, but you only get to retain possession as long as you stay in honor. The straw man stays in equity honor, and you fulfill your fiduciary duties as the presumed trustee. If you choose to go into dishonor, you voluntarily give up possession of whatever property the state wants to take to get the credits it needs to keep its business ventures going. Nothing personal, just business. Rule number 5. Do not participate in public plays. When the state invites the straw man to participate in one of its revenue events, you have options. The presumption is that you will volunteer to represent the accused straw man. They are pretty sure you will do that because you always have before. Think of the event as a play. The play has actors with scripts. Each actor knows the plot, his lines, and the outcome. Their play has been practiced over and over in every county. In every state, the outcome is almost always the same. A man, not one of the scheduled actors, crashes into their party, and carries out the plot. Without the man, the whole plot changes, the outcome changes, they need the man to get the same ending as they always have before. When the man does not participate in their play, there is confusion and chaos. The planned script does not work without the man. The usual scenario includes the man volunteering to represent the accused straw man, as a trustee. Each time a straw man is charged, a new trust is created. It is even possible that each time the straw man's name is spelled in a slightly different way in the complaining presentment, a different trust is created. There might be 2 or 4 different trusts referenced in the same presentment. Each trust is going to produce income for the plaintiff, if the script is followed as planned. It all has to do with trusts. Everywhere you look, there are trusts. The straw man is a trust when it is named on a complaint, indictment, or traffic ticket. Sometimes it is a cestui trust when it is the beneficiary of another trust. Sometimes it is the trustor or another trust. Sometimes it is a corporation sole. Sometimes it is a defendant. Sometimes it is a plaintiff. Sometimes it is a debtor. Sometimes it is a creditor. Sometimes it is a secured party. It is a very versatile vehicle or tool. There are always at least 3 parties to a trust. No one owns a trust on the private side, but on the public side, there is always a responsible party, who is deemed to be the owner to the trust. This is a fallacy that is often used by the state in relation to trusts that have real property as the trust corpus. They always want to know who the owner of the trust is. A trust is just an agreement among 3 or more parties. The trustee holds the legal title to the trust corpus, and is the one deemed to be owner of the public trust. It is useless to argue with public property or is involved with Federal Reserve notes. It qualifies as a public trust. The beneficiary holds the equitable title to the trust corpus. The title is bifurcated. Trust, a legal entity created by a grantor for the benefit of designated beneficiaries under the laws of the state and the valid trust instrument. Indenture, the document which contains the terms and conditions which govern the conduct of the trustee and the rights of the beneficiaries. Exchanger, exchange, to part with, give or transfer for an equivalent. Truster, one who creates a trust, also called settlor. Settlor, the grantor or donor in a deed of settlement. Also, one who creates a trust. Trust corpus, Trust property, the property which is the subject matter of the trust. The trust res. Creator. One who creates. Trustee. Person holding property in trust. One who holds legal title to property, in trust, for the benefit of another person, beneficiary, and who must carry out specific duties with regard to the property. Legal title. One which is complete and perfect so far as regards the apparent right of ownership and possession, but which carries no beneficial interest in the property, another person being equitably entitled thereto. Beneficiary. One who benefits from act of another. Equitable title. A right in the party to whom it belongs to have the legal title transferred to him, or the beneficial interest of one person whom equity regards as the real owner. Surety. A person who is primarily liable for payment of debt or performance of obligation of another. Creditor. One to whom money is due, and, in ordinary acceptation, has reference to financial or business transactions. The original straw man trust, Mom was the exchanger, truster, settlor.